Material. Araya Kabid and Sultan Qasim. 98. Unit 3 Choice of Law. Unit objectives. By the end of this unit, students are expected to explain the three methods of approaching choice of law problems, the general process of choosing an applicable law, what characterization and the related concepts mean, how the problem of renvoi is created and how can it be solved. The application, a foreign law. What is meant by a foreign law is a fact. How a foreign law can be proved and what the possible solutions are in cases of failure to prove one. The concepts of public policy and rules of immediate application. What incidental issue means and how conflicts addresses it. How evasion or fraud affects the normal functioning of choice of law process, and how constitutional principles can facilitate choice of law. The main choice of law theories are discussed in Chapter 1, Historical Development of Choice of Law Theories. Conflict students can have a glimpse of those theories before proceeding to the following reading. 3.1. Methods. Choice of law is the core element of the conflicts discipline. It is very muddy, controversial, and unsettled field. Many conflict scholars' minds and many materials have been invested for the development of a number of theories and assumptions and for the elaboration of the characteristics of the various proposed choice of law solutions. From the point of view of the ways they approached the choice of law problems, in the discipline of conflicts, the so far invented methods can be crudely categorized into unilateralism, multilateralism, and substantive law approaches. They were introduced at Conflict of Laws Teaching Material. Araya Kabid and Sultan Qasim. 99. Different times with different goals requiring different types of analyses. A unilateralist approach is premised on the idea that a state can only determine when its own law could be applied to a case. In other words, this approach deals with the determination of the personal and territorial reach of the potentially applicable local rules of decision. It determines the spatial reach of a certain state's substantive laws. The interposition of choice of law rules between multi-state transactions and legal systems is called the multilateral approach. According to this approach, if there are many laws to be applied and an issue to be solved, then you determine whether the issue or legal relationship has a strong relationship with one or the other law, and finally decide the case in accordance with the legal system with which the law has strong relationship or has most close connection. The third and a bit different from the above two approaches is the substantive law approach, which is a policy-oriented approach in which substantive policies directly determine the outcome of the choice of law process. This approach is characterized by the creation of rules of decision that directly govern multi-state transactions. In this theory, one has a certain purpose to achieve and one will apply the law that promotes the result. Hence, result-selective or result-oriented approach. This method is also known as the teleological approach. Based on their chronological development, while the substantive law approach is designated as new choice of law method, the other two, on the other hand, are grouped together for their common features into the classical or traditional choice of law method. They are also known by the collective name orthodoxy approach. The traditional method, born mainly to the German scholar von Savigny-Sitz theory, in 1849, which has got two important and main components are categories of laws such as family, contract, tort, and connecting factors such as place of celebration of the marriage, common domicile of the parties, place of wrong or injury, and place of performance is engaged principally in the furtherance of decisional harmony or uniformity of judgments, to avoid or reduce forum shopping, ensuring predictability, and certainty. This approach is based on the premise that choice of the applicable law is determined by conflict of laws teaching material. Araya Kabid and Sultan Qasim. 100. The center of gravity of the legal relationship at issue. But how can the center of gravity itself be established? The center of gravity or closest connection can be set up in the abstract or on the basis of the actual facts or circumstance of a given case. Under this approach, a multi-state case is seen as a legal relationship that is drifting about and that must be allocated to the appropriate place where it belongs using certain criteria called connecting factors that can help one determine the existence of factual most close connection of the specified legal relationship with a certain jurisdiction. As a result, this choice of law process is called the allocation method. Choice of law systems in which the allocation method is employed depend on a set of choice of law rules, each of which covers a specific category of legal relationships, for which it contains an appropriate connecting factor. The choice of jurisdiction to which the connecting factor refers entails the choice of the law of that jurisdiction, and that is invariably expressed in the third component of this type of rule, next to the choice of law category and the connection factor. Under the allocation method, besides the factual allocation, there are choice of law rules that advance different interests or values. These are, first, functional allocation, in which the connecting factors do not necessarily establish the strongest factual connection but refer to the jurisdiction that may be deemed to have the strongest interest in the application of its law. These connecting factors are based on the idea that certain areas of law under the favor principle promote certain important social values, especially protecting some vulnerable groups such as children. Second, party autonomy principle, in which the connecting factor does not necessarily aim to establish the closest factual connection but refers to the jurisdiction whose law the parties themselves have chosen. This principle mainly functions in those areas in which the parties enjoy a large measure of freedom to shape their legal relationship as they see fit. The parties are not allowed to set aside compulsory rules. Beyond that, they are at freedom to agree as they like. The notable instance is the contract by the parties to a marriage concerning their pecuniary relationships. The other category of choice of law method is known as interest analysis. While considering a multi-state case, the proponents of the new or rule selective as opposed conflict of laws teaching material. Araya Kabid and Sultan Qasim. 101. To the old, or traditional approach propounded that instead of employing the jurisdiction or state selective approach, which affects choice by a process of finding a legal category qualified to supply the rule of decision because of a significant connection with the case, the decision maker should choose directly between the specific substantive rules of the legal systems variously connected with the case by an evaluation of the rules with a view to finding the solution which best fits the situation, in light of the circumstances, of the comparative merits of the potentially conflicting substantive rules available. Demand of justice is the underlying principle in this value-oriented approach. While the question, what should be the proper result in a given case, pertains to the new system, the question of that of the old method is what rule is the proper one to select a jurisdiction whose law should govern it. The nature of the new method is more plastic, for it permits individual ad hoc solutions, making the discipline responsive to the demands of substantive policies. The views of the substantive justice held by the different possible applicable substantive laws are taken into account. This means, in Lorenzon's uncompromising depiction, the country's worry in a choice of law case should be, what are the demands of justice in the particular situation? What is the controlling policy? In other words, the dominant determinants of problems in the field are consideration of values of justice and social expediency. This method has the tendency of testing all the substantive rules of the relevant laws involved. 3.2. The general part of choice of law process. One can ask what a court is required to do if a case with an extra state element is brought before it. As in any ordinary fully domestic case, the court has to identify the facts and find out the appropriate law to resolve the issues of the facts. In conflicts cases, it is a bit complex. It involves transaction or parties that have a certain connection with a jurisdiction outside the forum. A different mechanism is called to resolve the matter. The court has to pass through a number of processes in order to dispense justice to a conflicts issue. Let us begin with the first stage of the process of choice of law: characterization. Conflict of laws. Teaching material. Araya Kabid and Sultan Qasim. 102. 3.2.1. Characterization. The nature of choice of law rules places large emphasis upon the process of characterization. Characterization can also be termed as categorization, qualification, or interpretation. Conventionally, this stage, i.e., characterization, has got three sub-stages within itself which are taking place in the determination of any conflict of laws questions. They are, first, determining the juridical nature of the problem presented to the court. Second, selection of the appropriate connective factor, and third, delimitation of the proper law or to determine the extent of the application of the chosen law. In other words, it involves the characterization or classification of the subject matter or the issues in the case, for example, family, contract, etc., and of the nature of each issue and whether it raises a problem of procedure or of substantive law. The first sub-stage presumes that the domestic laws of each state are classified and grouped into different established categories. The court at this sub-stage assigns the facts of the situation or the disputed question to the appropriate legal category settled beforehand. Classifying into one legal category or operative fact is important, for the forum's law may regard a case as falling into one legal category, but the relevant foreign law believes it to belong in a different one. A case can be solved only if a law devised to resolve such type exists. Moreover, the facts of the case should be distinct enough to be matched with a given law_legal category. Still more, an issue of the facts of the case should be able to be categorized into only one legal category to be resolved thereof. An issue should be either of family or contract and not both at the same time. Which legal category is to control a given issue if more than one of the latter is applicable to the issue of the case. Therefore, subject matter characterization continues to be the natural and necessary starting point for the analysis of any conflicts case. As far as rules of choice of law are maintained, the problem area must be identified in order to see whether a conflict indeed exists, and the applicable rule of decision must still be chosen on the basis of a characterization of the subject matter, even if the case should present a false conflict but a Aurane law is applicable to the issue. Characterization of facts, in order to relate it to an already formulated legal category, is not unique to conflict of laws. Applying the legal categories to particular instances is conflict of laws. Teaching material. Araya Kabid and Sultan Qasim. 103. Commonly encountered in legal thinking and analysis, whether or not the case contains any factual elements that relate it to more than one jurisdiction. It is the regular and ordinary activity of the concerned practitioners, especially judges, to classify facts to fit predetermined legal categories in the problem-solving process. Conflict of laws situations, however, often encounter classification problems of greater than normal complexity, for most of the choice of law situations involve two or more different bodies of laws, each of which may use identical or nearly identical abstraction but in a bit different manner. Usually, the same term may be used differently in different rules in one system, and because conflict of laws problems involves more than one system of rules, the difficulty of characterization or classification is multiplied. Thus, the same word may have different meanings in the different systems involved depending upon the doctrinal context in which the term is found. This is so because the doctrinal context of any legal term includes the policy complex it is designed to implement in the system in which it is used. After dealing with the determination of the general legal nature of the issue, the choice of law rules appropriate to the legal category selected will be available for the solution of general legal nature of the issue. Here lies the second sub-stage selection of the appropriate connecting factor. Specific connecting factor will be employed for the determination of the applicable law once the subject matter of the case is classified. An example is the determination of whether the court has before it a family or contract question so that it may know whether to apply family or contract choice of law rules. In other words, this part concerns the definition and use of connecting factors, a term employed to describe the word or words in a rule of reference which indicates the place whose law may be used to decide the issue, such as place of celebration of marriage, domicile or nationality. The connecting factors, which are relatively few in number as are the legal categories of great breadth, are drawn from domestic law situations. They include the personal law, domicile, habitual residence and nationality, the place where the transaction takes place, as place of celebration of a marriage or the place of contract, the place of performance, as in contracts, the intention of the parties, the situs, the place where the court is sitting, and others. Another name parallel to connecting factor is situs. Conflict of laws teaching material. Araya Kabid and Sultan Qasim. 104. The third sub-stage relates to the extent of application of a law when the forum's choice of law rule refers to the law of another jurisdiction, delimitation of the proper law. In other words, it is a matter of an extent of the application of the law to which a reference is made. Does it include both the foreign substantive and procedural laws? Does it also include the foreign choice of law rules? This aspect of characterization distinguishes between issues of substantive law and of procedure. The forum will apply only the foreign substantive law but use its own procedural law for domestic and foreign claims indifferently. The main reason employed is that procedural rules are concerned with only methods and mechanics that do not virtually carry important policies or values sufficient enough to affect the basic outcome of the case. At this sub-stage, facts are not involved. It is about determination of whether a rule of law is substantive or procedural. Hence, legal aspect characterization. The first two sub-stages involve facts. When a judge qualifies, at sub-stage 1, he characterizes the whole factual situation, at sub-stage 2 he characterizes certain, particular, facts, and at sub-stage 3, he delimits rules of law. These inquiries of the court are also called characterization, selection, and application respectively. Despite the solution it provides for choice of law issue, characterization has some inherent problems. The approach as a whole, geared as it is to the classification of legal rules, can achieve the targeted goal decisional harmony or uniformity of decisions only if all legal systems classify their private laws in the same manner. However, it is not uncommon to see a right or an obligation to be classified in one legal category while the same is put in another category in a different state. F. Younger stated that this is unavoidable for historical happenstances and other factors rather than logic determines the manner in which a particular state or nation organizes its law. There is lack of consensus on how to arrange the legal rules amongst many states. If decisional harmony is to be realized, there should be a superior authority or a universal, or national for interstate relationship, agreement amongst states that force the latter to classify their private laws in a similar fashion. The targeted goal may not always be attained if states remain free to classify their legal rules as they see fit. Some instances of conflict of laws teaching material. Araya Kabid and Sultan Qasim. 105. The problem are, while limitation periods are qualified as procedural in some legal systems, others take it as substantive. This being a typical example, air crash defective products injuries involving cases can either be categorized as tort or contract. Still another example is that in order to protect the property rights of surviving spouses some legal system may rely on family law others on property or succession rules. In this connection, there is another extended problem during, especially procedure substantive classification, the problem of cumulation or gap. Suppose the forum is in Afar. The case is of a family nature between a Kenyan man and an Ethiopian, Afar girl. The judge sitting in a court in the Afar region, while characterizing the applicable law found it to be substantive according to the Kenyan legal system but of procedure as per the Afar family law. Here, since the connecting factor pointed out the Kenyan law, the latter law should be applicable. But the Ethiopian court found it procedural and the forum's procedural law is always applicable. Then both laws are found to struggle to be applied. Here is the problem of cumulation to be encountered. Let us reverse the situation. The forum is, again in a far region. While characterizing, the law has happened to be procedural according to Kenyan law which, however, is not to be given effect, but as to the Afar law, the particular rule was found to be substantive, which, however, according to the process of the traditional method the Kenyan law should be applied. But the Kenyan law is interpreted to be procedural cannot be applicable. Here the two laws are not to be applied. There will be a problem of gap and the case will remain without solution. Another problem is that some states' legal systems lack certain institutions like betrothal in the revised Family Code and Tigray family law. The law of separation, not necessarily divorce, is not known in virtually all the regional family laws. The same holds true in the international arena. For example, the law of trusts, which is unknown in France, is well known in the USA. It is difficult to devise conflicts categories for which there is no counterpart in a municipal or internal law. It will not be possible for Ethiopia's conflicts law to deal satisfactorily with the institutions of judicial separation, trust, space law, etc., which are not known. Another problem is that various legal systems employ different legal institutions to solve conflict of laws teaching material. Araya Kabid and Sultan Qasim. 106. A given case. F. Younger has delivered a hypothetical but possible to happen family case. A married couple moves from an American state, say Michigan, which protects the surviving spouse's interest by giving the indefeasible inheritance rights to a community property state such as California. In Michigan the husband had accumulated property, while the wife looked after the household. When he now dies domiciled in California without leaving a will in her favor, to what is she entitled? According to the traditional American conflicts rules, the spouse's property interests are governed by the law of their domicile at the time of acquisition, whereas the law of the decedent's last domicile controls the distribution of movables. The wife therefore acquired no California community property rights, for the husband's wealth was produced in Michigan, the couple's former domicile. Nor can she inherit under Michigan law, for the husband was domiciled in California at the time of his death. Still another problem is the manner in which characterization is to be approached. The approaches have varied as to whether all or any the sub-stages of characterization are to be determined by the doctrinal context of the forum or of the other legal systems involved. Some argue that the lex fori should control the characterization process, others the lex causi. Yet others advocate supranational concepts derived from the comparative method. The subject matter characterization is controlled, for pragmatic or practical necessity, and not logic, by the forum's legal system including its conflict of laws. However, the lex fori cannot be applied in case of unknown areas of law to the forum's legal system and when the forum is serving as a mere place of trial without any connection with the transaction enough to establish an interest. While there is no agreement as to the other sub-stages of characterization, some take policies of the concerned states into consideration. For identifying the significant connecting factor is an integral portion of the conflict of laws doctrinal context to which the courts of the forum look for guidance. Their significance is subject to the policy of the forum reflected in its conflict of laws doctrines. Finally, since one purpose of the conflict of laws doctrine is to achieve some measure of uniformity of results without regard to the choice of forum, the law of the state under consideration in the third sub. Conflict of laws teaching material. Araya Kabid and Sultan Qasim. 107. Stage should be viewed in its own policy context. 3.2.2. Renvoi. Renvoi is a French word literally meaning to send back. Let us put a conventional and readily understood typical example as a framework for the discussion of the concept. An Englishman dies domiciled in France and a question arises in an English court as to the distribution of tangible movable property which he leaves in England. It is a well-established English law that a decedent's property is distributed on death according to the law of the country of his domicile. Let us say, however, that the conflict of laws rule applicable in France is that an alien decedent's property is to be distributed according to the law of the county of his nationality, which in our case is English. While characterizing, the choice of law rules of the forum might call for the law of another state to be applied. Unless there is clear indication otherwise, a question might arise whether the reference to the concerned foreign law encompasses the choice of law rule of that jurisdiction, the whole law, or to the internal law only, that is to mean, the law which a court would apply to a situation all of whose elements were domestic, to the exclusion of choice of law rules. Here, in the above example the question obviously arises, when the English conflicts rule directs the case to the law of France, is the reference to simply to the internal law of France, that is, the law which a French court would apply to a situation all of whose elements were French, or is it to what may be called the whole law of France, including not only the French internal law but also the French rules of conflict of laws? The Renvoi issue arises if the reference made is to the inclusion of the foreign choice of law rules. The connecting factors employed by the forum and the foreign choice of law rules that refer to the applicable law or legal category for the resolution of the cases with an extra state element must be different. If the connecting factor, for the same legal category, of the jurisdiction referred to is similar to the forum S, there will not be any question of renvoi, since the relevant choice of law rule of that state orders for the application of the internal law to the issue at hand. For a renvoi, especially true renvoi, to arise, the relevant choice of law rule of the foreign state, state X, to which we have been. Conflict of laws teaching material. Araya Kabid and Sultan Qasim. 108. Referred by the relevant choice of law rules of the forum, state F, sends us back to the choice of law rule of the state F, since the state F choice of law rule is the one that originally sent us to the state X choice of law rule. A return to the state F, S choice of law will only send us back to the state X rule, which will send us back to the F rule, etc., in a kind of circular perpetual motion that will never give us an internal substantive rule. In the above example, if the reference made by the English law is to the whole law of France, the French law, its choice of law rules, refers back to the law of England, and the same question arises again. If in each case we refer to all the laws, including the conflicts rules, we are apparently on a merry-go-round roundabout or indirect, or not to use the shortest way. The renvoi situation has been designated by many conflict scholars, to whom the doctrine is anathema to, by their colorful, but unfavorable expressions like a game of lawn tennis, international lawn tennis, or ping-pong, a logical cabinet of mirrors, and as a circulus inextrabilis, or endless circle. The true renvoi doctrine is sometimes called the double, or total, or English, since it appears to be peculiar to English law renvoi. Here, the reference to the foreign law is including to its choice of law rules and renvoi if they include it. In actual practice, the reference in the foreign choice of law rules may not, however, always be back but to the law of some other third state. This is not a true renvoi. A typical example is where the decedent, whom the English court regarded as domiciled in France, was a German rather than an Englishman. If the court, following its rule of domicile, refers to the law of France, and understands this to mean all French law including its choice law rules, it may be referred by the French law to the German law, as Germany the nationality of the decedent. This reference, across rather than back, is sometimes designated as transmission, while the case of true renvoi is said to be a case of remission. Renvoi is a problem. Renvoi is considered as a problem and sometimes even as a necessary evil, for it causes many intricacies. Many countries wanted to do away with it. How is it possible? As Griswold has examined it, the extensive literature on the doctrine has found out about conflict of laws teaching material. Araya Kabid and Sultan Qasim. 109. 4 possible ways of dealing with the question. I. Rejecting the renvoi. The reference to the foreign law does not include to the choice of law rules of the latter. We will elaborate this below. 2. Accepting the renvoi. If state X, S choice of law rules refer to state Y, S, whole law, and state Y, S choice of law rule refers back to state X, S law, then the second reference towards state X, S law will be taken only to the internal law of state X, taking Y is refusing to apply her law. 3. The Sistman theory. The reference by state X, S law to state Y, S law has produced no state Y, S law applicable to the situation. There is nothing else for the state Y, S court to do but apply state X, S law. IV. Here, state X, S judge is referred by his choice of law rule to the law of Y. What is the law of Y? It is the law which state Y, S court would have applied to the same case. Then if state y(s) court would have applying y(s) internal law either because it accepts the renvoi or for any other reason, then state x(s) court should apply state y(s) internal law. If state y(s) court would apply state x(s) internal law either because it rejects the renvoi or for any other reason, then state x(s) court would apply state x(s) internal law. And, if state y(s) court would apply state z(s) internal law, and then state x(s) court would do the same. This is sometimes called the single, or partial, renvoi, or renvoi simplicitor. Here, the law of state y means including its choice of law rules but minus its choice of rules applying renvoi, if it has any. There are some, but one less persuasive, arguments forwarded against renvoi as an objection to its application. The one that seems sensible objection is, there is no logical reason why the process should ever stop. A reference back to the forum would trigger the process anew. The double renvoi would not operate at all had it not been for the rejection of the same by other countries. The problem of ad infinitum could exist if, and only if, a case happened to be in between two states that adopt double renvoi. The case will be suspended eternally. Despite all these, the problem is, at least for the moment, theoretical, as double renvoi is peculiar to the English law. But if some other states. Conflict of laws teaching material. Araya Kabid and Sultan Qasim. 110. Conflicts law also employed the double renvoi method and the horrendous consequences were about to ensue. One cannot help thinking that courts would put a stop to it somehow. It would be better not to plead in favor of renvoi at all. Other objections, but feeble, are, first, the forum's conflicts rules should not be displaced by those of other jurisdictions by applying renvoi. A court is yielding to a foreign court instead of applying the forum's choice of law rule, it is applying foreign state's choice of law rules. Collier, responding to this objection, wrote, "It is not an abdication in favor of foreign state's choice of laws, and the process is undertaken only because the forum's courts wish to undertake it. It only occurs because the forum's choice of law rule leads to the application of foreign choice of law." Moreover, Scholes and Hay, responding to the above immediate objection along with the objective that renvoi is a manipulative device to explain the application of a different law, states that these objections overlook one of the important objective of conflicts law, to minimize the effect that litigation was commenced in this rather than in another forum and to achieve, to the greatest extent possible, uniformity of decisions. While one misguided or exaggerated objection to a so-called problem which is not peculiar to renvoi is its difficulty to ascertain whether the foreign system of law does or does not apply it. Another problem is that a difficulty arises if the foreign court, should it be seized of the case, would apply the law of a person's nationality. While being a country of a federal structure and there is no what is called national law, but different laws respective to the constituents. To which of the several laws is the reference made? To the law of the unit the person belongs. To his residence or domicile law. Two arguments furthered in favor of renvoi by Younger are, the one concerns the construing of the reference to foreign law in the forum's choice of law rule to mean that rules of decision which the court in the foreign country can be expected to apply. This approach, though not logical, certainly makes sense. This solution, by which a judge puts himself into the shoes of his foreign counterparts, foreign court theory, has the incontestable merit of guaranteeing a modicum of decisional harmony. The other argument concerns the partial renvoi approach. Although it does not produce uniform results, this approach at least permits judges to apply the law with which they are most. Conflict of laws teaching material. Araya Kabid and Sultan Qasim. 111. Familiar. However, the latter solution encourages forum shopping, which the logic of Renvoy is aimed at avoiding by ensuring the realization of uniformity of judgment, the goal of the tradition method. In this partial Renvoy doctrine, determination of rights is more likely to depend on where the action is brought. 3.2.3 Public policy and rules of immediate application. When one selects the applicable foreign law, after exhausting all the relevant techniques of conflicts rules, one encounters a serious question test of public policy. It is not every foreign law chosen to be applicable that deserves a hearty welcome by the forum court. The vague and many elements encompassing concept, i.e., The vague and many elements encompassing concept, i.e., public policy, is there to limit the normal operation of the choice of law rules.